Hi everyone, I'm Yuda, a Japanese immigration lawyer. Today, I would like to explain two major developments regarding Japan's naturalization system that have been widely reported since around November 2025. The first is a discussion being considered by the government about raising the residency requirement for naturalization. Specifically, there is a proposal to change the requirement from the current 5 years to 10 years, the same as permanent residency. The second is a proposal put forward by the Japan Innovation Party, which argues that Japan should introduce a new system to revoke naturalized citizenship. Today, I would like to explain these two developments and discuss how realistic they are. First, let me give you my conclusion up front. Regarding the first issue, raising the residency requirement for naturalization from the current 5 years to 10 years in line with permanent residency, I believe this is entirely possible and in fact highly likely to be implemented. The gap between 10 years for permanent residence and 5 years for naturalization has long been criticized in political discussions and public opinion. From an institutional perspective, it is reasonable to argue that citizenship, which carries a heavier legal status, should require a longer period of residence than permanent residency. On the other hand, regarding the second issue, creating a system to revoke Japanese nationality, I believe the hurdles are extremely high, and it is unlikely to be realized. Japan does not in principle allow dual nationality. Many people lose their original nationality at the time of naturalization. If Japan were to introduce a system that revokes citizenship, it would risk creating stateless persons. A state intentionally creating stateless individuals is not permissible. Therefore, if such a revocation system were ever introduced, it would require a very complex mechanism that guarantees the person will certainly regain another nationality after revocation. For this reason, compared to raising residency requirements, the likelihood of implementing a citizenship revocation system is quite low. With that conclusion in mind, I will now explain in order the reasons behind these views. 1. Raising the residency requirement for naturalization. First, let's review the current rules. Under Japan's Nationality Act, so-called ordinary naturalization requires that the applicant has had a domicile or residence in Japan for 5 consecutive years. Meanwhile, for permanent residency, according to the Immigration Services Agency's guidelines, the general rule is at least 10 years of residence, of which at least 5 years must be under a work-related residence status. If we simply compare the numbers, permanent residency requires 10 years, while naturalization requires only 5. This has long raised the question, isn't it strange that acquiring Japanese nationality, a more significant legal status, requires fewer years of residence than permanent residency? This question has repeatedly been raised in political debates and public discourse. In response to this, the Kishida administration held the first meeting of the Ministerial Conference on the Realization of an Orderly and Inclusive Society for the Acceptance of Foreign Nationals in November 2025. At that meeting, the Prime Minister instructed the relevant ministries to compile a basic policy on tightening naturalization requirements by January 2026. This means that by around January 2026, we should have a clearer picture of whether and how naturalization requirements will be tightened. Now, speaking from my perspective as a practitioner who handles naturalization cases on a daily basis, I would like to share my thoughts. First of all, I believe that simply comparing residency years and concluding that naturalization is easier than permanent residency is somewhat misleading. Residency is only one of many requirements for naturalization. In actual naturalization screening, authorities conduct a very detailed examination of many factors, including criminal history and compliance with laws, daily conduct and lifestyle tax payments and social insurance contributions, the financial stability of the entire household, information about family members in the applicant's home country, Japanese language ability, and degree of integration into Japanese society. Although Japanese language ability is not explicitly stated in the law, it is heavily emphasized in practice. Authorities also examine whether the applicant respects the Japanese constitution and genuinely intends to live as a member of Japanese society. All of these factors are examined carefully through documents and interviews. From a practical standpoint, while permanent residency is certainly subject to strict screening, naturalization tends to involve broader and deeper scrutiny because it grants the extremely significant legal status of citizenship. Therefore, the idea that anyone can easily obtain Japanese nationality after just 5 years is, in my view, a misconception from the standpoint of those working in the field. That said, does this mean the current system of 5 years for naturalization and 10 years for permanent residency is appropriate? I do not think so. Residency duration is a core requirement for both naturalization and permanent residency. Having a lighter residency requirement for citizenship than for permanent residency creates a lack of consistency in the system. For this reason, I believe that the argument to align the residency requirement for naturalization with that of permanent residency has reasonable justification. However, careful discussion is necessary when it comes to simplified naturalization categories such as special permanent residents, former Japanese nationals, or those married to Japanese citizens. Whether these categories should also see stricter requirements must be debated cautiously. At the very least, for ordinary naturalization, I believe there is a strong possibility that the residency requirement will be revised in a direction closer to 10 years. 2. Proposal to create a citizenship revocation system. Next, I would like to discuss the proposal by the Japan Innovation Party to introduce a system for revoking naturalized citizenship. First, as a premise, Japan's current Nationality Act does not contain any explicit provision for a general citizenship revocation system. Naturalization is an administrative disposition made by the Minister of Justice. In theory, if there were serious defects such as fraud or false statements at the time of application, revocation might be possible under general principles of administrative law. However, in practice, cases where naturalization has actually been revoked are extremely rare, and there are almost no widely known precedents. As a result, questions such as what can be done in cases of fraudulent naturalization and to what extent revocation is possible have remained in a long-standing gray area. Against this background, in September 2025, the Japan Innovation Party published a policy proposal on foreign resident and immigration issues. This proposal included stricter naturalization screening and the creation of a citizenship revocation system, and was formally submitted to the Minister of Justice. According to media reports, the proposal suggests that in cases of serious false applications, terrorism, or acts that fundamentally threaten the state, Japan should introduce a system that allows citizenship to be revoked after judicial review. As for my own opinion, I do not categorically deny the concept of a revocation system itself. Other countries do debate how to respond to extreme cases such as clear fraud or terrorist acts. However, in Japan's case, the fact that dual nationality is generally not permitted creates a major obstacle. Many people lose their original nationality upon naturalization, or are scheduled to do so. If Japanese citizenship were revoked, there would be a high risk of creating stateless persons. Article 15 of the Universal Declaration of Human Rights states that everyone has the right to a nationality. A state cannot adopt a system that intentionally produces stateless individuals. Therefore, if Japan were to introduce a revocation system, it would need to be paired with a mechanism that absolutely guarantees the restoration of the original nationality or the acquisition of another nationality after revocation. Without such safeguards, introducing a revocation system would risk moving in a dangerous human rights violating direction. Conclusion. To summarize, raising the residency requirement for naturalization is highly likely to be implemented. Creating a citizenship revocation system faces serious challenges related to statelessness and international human rights, making it unlikely to be realized. Today, I discussed these two issues: the government's consideration of raising residency requirements and the Japan Innovation Party's proposal for a revocation system, and examined the direction in which Japan's naturalization system may move. Personally, while I believe it is misleading to say that naturalization is easier than permanent residency based solely on residency years, the current situation, where citizenship requires fewer years of residence than permanent residency, does raise issues of consistency within the system. Going forward, I hope that discussions will proceed calmly and carefully, with close attention to overall institutional balance and, above all, to human rights, especially the principle of not creating stateless persons. Thank you very much for watching.